So in 2019, a research scientist named Stephen Thaler um, tried to get a patent on an invention that was supposedly created by an artificial intelligence piece of software. And to put it mildly, the world freaked out because the future was here, the future was now, and we needed to get our arms around, what exactly we're going to do with AI in terms of recognizing the outputs that it creates. And so the USPTO, that was like in June of 2019, sometime I think it was in August of 2019, the US Patent and Trademark Office. First, they had a conference, a seminar on AI and IP and policy. And then in August, they issued a request for comments on AI in the patent context, ownership. And then that got expanded in October of 2019 to copyright. I was at the time co-chair of the American Bar Association's Copyright and Emerging Technology Committee, along with Janet Driver. Janet, it's great to see you. And Janet and I, just out of happenstance, in part of 2018 and 2019, had an ad hoc group addressing these exact issues. We had folks from the technology space, we had folks from the content space, and we were trying to work through when is AI should own it, who is the author, where does authorship come from, and so we were ready in October of 2019 to address these issues. We had Mary Rassenberger from the Authors Guild was on my committee, and Dave Green from Microsoft, and a number of other folks with different perspectives. And what we basically said in response to the PTO's queries was, look, artificial intelligence itself cannot be the owner. The program cannot be the owner of a copyright, because it's copyright's only for human authorship. It's for incentivizing human authorship. But we punted on a lot of the issues, a lot of some of the other issues. And what comes out of it is really twofold. One is this ownership issue, who should own what AI generates. And then there's also the liability issue. What kind of infringement questions are posed by the data mining and the scraping and the downloading of content necessary to train the AI models. So, the U.S. was very active in it. So was the EU. WIPO, similarly put out a request for white papers. And the future again is now in February of 2022. The same individual, Dr. Thaler, tried to get a copyright registration on a piece of artwork that he claims was created by the creativity machine. And he claimed he had no involvement, with this artwork, and tried to identify the AI software as the entity that that was the author. He claimed to own it by way of work for hire. And the Copyright Board, he was rejected at an initial level, went through a level of appeal, and then a final level of appeal. The Copyright Review Board denied that claim. And in my view, and if I ever get my act together, you all will get a very long blog post on this, hopefully in the next week or so, is that it's hogwash, okay? That what Thaler is doing, respectfully, is showboating and really misdescribing how AI works, right? And part of it's a semantic problem. We talk about machine learning. The machine's not learning. That's an easy sort of heuristic rule of thumb, okay, for what is going on here. AI, as I understand it, is a probability machine, right? It takes what are called feature vectors, and by trial and error, it refines at a very fast pace, faster than we can do. It processes, different parameters, different weights and measures, until it achieves a certain result that the trainer says, yep, that's what I'm looking for. And it does that over and over and over again until it refines outputs that meets the requirements of the developers, training the AI model. So it's not as if the AI is conscious. We're not talking about HAL from 2001 Space Odyssey. We're not talking about C-3PO here. Okay, what we're talking about is a Rube Goldberg machine, okay, of all the rules engines, of all this different data, that is an iterative process that yields a set of results and outputs.